Okay, I'd like to now pass over to Robert Collings for the main presentation for today. Robert is the General Counsel and Head Solicitor here at MBA New South Wales, and he's been a solicitor for 36 years now, specialising in building and construction for more than 20 years there as well.
Welcome everyone to my office. The membership girls have been up and closed my doors and strategically positioned the webcam so that it doesn't show the rest of my office, that anyone that's ever been in here will know it's a work cover hazard. So well done there. It also means I can stay in my comfortable chair, although we had to swap it for another one that wasn't squeaky. Okay, now the purpose of this is to introduce residential builders to the Building and Construction Industry Security of Payment Act. Most even residential builders will be familiar with the Act in as much as its application to subcontractors who have made claims against residential builders since the Act. It's a 1999 Act, but it came into actual operation, I think, in 2002. So it's been around for just coming up to 20 years. And Master Builders has been advocating right from the very beginning that this Act should apply to homeowners. It's not consistent with resolving non-payment in the building industry to not have homeowners applied under the Act. In our view, a lot of the insolvencies, if not most of the insolvencies, certainly by number, that's caused in the building and construction industry is against small builders who are in the residential market, and they make up by far the greater numbers in the building and construction industry. The acts or security payment acts in their different formats have operated well in other states, including against homeowners. And in the most recent amendments back in September of last year, the New South Wales government has finally decided that yes, homeowners should be part of the Act now, or the Act should be applicable to the homeowners. So there's going to be a few little tweaks to this. We were a little surprised at it. The Master Builders has advocated for a few extra things to come with the Act. The government didn't pick up on that, but they will be doing other things in as much as there's going to be a guide of some description that's going to come out in the next few weeks, I believe, that will be required to go into residential contracts with owner-occupiers. We'll keep you informed about that. Our contracts will be amended. It'll be amended on the electronic format almost immediately, and for the over-the-counter or hard copy, there'll be an insert that goes in when it's required. So my intention today is to simply give you a quick summary of how the Act works and how it applies to you as a residential builder, and how to use it against homeowners in particular. It's only meant to be a quick glossy overview. We've really only got less than half an hour to go through it. Security of Payment Act can get very complicated. It started life as a relatively simple procedure whereby subcontractors in particular could claim monies against builders, and it was meant to be a quick form of getting paid and not a final form of the dispute between a subcontractor and a builder. It could also be used by the builder in the commercial context and some limited contexts in the residential sector, such as strata plans, developers and investors. But now it's applicable to the owner-occupiers. So we give a quick summary of it now. We're going to put on some more detailed seminars that'll will take at least a couple of hours. I was going to say that will bore you for at least a couple of hours. It's not exciting stuff, the security of payment, but you need to know it, and it can be a very effective tool in getting paid quickly. It doesn't resolve the dispute, because the dispute can still go on to, in the residential sector, to NCAT, the New South Wales Civil and Administrative Tribunal, or the local courts or district courts, but it will hopefully ensure payment quick payment for reasonable amounts of money. So we'll put on those more detailed courses. Keep an eye out for those. And of course, for members, you're welcome to give us a call as you're going along. By all means, ask as many questions as you want. That's why we're here. So getting on with it. The legislation. Now, first of all, this is a payment claim made under the Building and Construction Industry Security of Payment Act 1999. That is what's commonly called the endorsement. Now, again, you may be familiar with it. Most builders are by now, and usually it's subcontractors putting it on their invoices when they're claiming against a builder, or subcontractors against a subcontractor. Now, a builder can now use the Security of Payment Act against an owner-occupier. Therefore, to invoke the Act, to make your invoice, for want of a better term, a payment claim under the Act, you need to have the endorsement or words to that same effect on your invoice. Now, you don't have to. It's simply, if you want to use the Act, you then put the endorsement on it. As I said before, the Master Builders has been advocating the government for quite some time to bring in the Security of Payment Act against homeowners. And what we originally advocated was for a more detailed endorsement to go on invoices that would explain to owners the ramifications of not responding to an invoice that they don't intend to pay. But that wasn't picked up, and instead they just simply changed it over to including owner-occupiers. But they've now decided that that's going to lead to a little bit of confusion amongst homeowners, because they don't know what the Act is about, and they've now indicated that they will be producing a guide, as I said before, and that guide will be required to go in the contract. Excuse me. Now, that is a little bit controversial as well. The reason that they're going to produce the guide to go in the contract is because, in the department's view, the Act amendments only apply from the 1st of March. There is some legal viewpoint that the Act now applies to claims made after the 1st of March. So it does apply to contracts made before the 1st of March. But the department is most definite that that was not the legislative intention, and they've produced in writing their view that it applies from contracts, for contracts signed on and from the 1st of March. And I think, despite my reservations with that viewpoint, I think that's the viewpoint we'll have to run with, because to do so otherwise may involve a lengthy and expensive court case. Okay, so again, that's the usual wording of the endorsement that goes on an invoice. Now, it's for residential contracts, as I've just mentioned, that are signed after the 1st of March 2021. Now, my next thing is the Act. Section 3 of the Act gives the objects of the Act, and I think Section 3 gives a pretty good summary of what the Act is all about, what it's meant to do, and how it does it. So I'm going to bring up the actual wording of Section 3, and I'll read from it. And as I said, it's a pretty good summary. The object of this Act is to ensure that any person who undertakes to carry out construction work, or who undertakes to supply related goods and services under a construction contract, is entitled to receive and is able to recover progress payments in relation to the carrying out of that work and the supplying of those goods and services. Now, just a quick aside on that, the reason for that is, it may surprise builders, but there's no entitlement at law to progress payments. So unless you've got a contract that says you're entitled to progress payments, the law says you must finish the contract, complete the contract, before you can put your hand out for any money. Now, of course, in the building industry, that's fairly difficult, because most building and construction work involves a fair amount of money, and it usually goes over a reasonable period of time. We're not talking about a transaction that takes place fairly quickly. So to prevent the common law position of an intransigent builder not paying and insisting on completion of the contract work. The Act was brought in to enable subcontractors and builders in the commercial context to be able to claim progress payments as you're going along. Of course, quite often it is dictated by the contract, but in subcontracts in particular, it's not, and that's why the entitlement to make progress claims came in under the Act. Of course, it's not going to matter too much with the residential builders making a claim against your average homeowner, because the average contract will have progress claims in it. At the moment, predominantly the scheduled claims, so the staged claims in most fixed price contracts, and the periodic claims in a cost plus contract, which is another quick aside, I'm sorry. But it's also curious to note that one of, I think, the inadvertent effects of bringing homeowners in under the Act was the previous compulsory requirement in a fixed price contract to claim only staged claims has now gone, because that provision only applied to exempt residential contracts where the Security of Payment Act did not apply. Now that the Security of Payment Act does apply, that provision is no longer compulsory. So residential contracts can now be either periodic claims, which are weekly, fortnightly, or monthly, based on the value of the work done, or you can still keep your staged claim regime. We'll actually be amending the contracts accordingly shortly. Okay, enough asides, let's move on. Now, subparagraph 2, the means by which this Act ensures that a person is entitled to receive a progress payment is by granting a statutory entitlement to such payment, regardless of whether the relevant construction contract makes provision for progress payments, which is pretty much what I've already summarised. Over the page to subparagraph 3, the means by which this Act ensures that a person is able to recover a progress payment is by establishing a procedure that involves A, the making of a payment claim by the person claiming payment, and B, the provision of a payment schedule by the person by whom the payment is payable, and C, the referral of any disputed claim to an adjudicator for determination, and D, the payment of the progress payment so determined. So we'll get into that in just a little bit more detail. Again, I don't want to go into it to enormous amount of detail. But then subparagraph 4, it is intended that this Act does not limit any other entitlement that a claimant may have under a construction contract, or any other remedy that a claimant may have for recovering any such other entitlement. Now, that is quite important. The Security of Payment Act does not bring about a final decision in relation to the monies owed by the homeowner to you, the builder. It is meant to be a quick form of getting your money, not a final decision. So if you as the builder make an adjudication application, you get a decision, you're not happy with it, you think you deserve more money than what the adjudicator has given you, you can still go to court and sue for the balance of the money. A homeowner, on the other hand, who may not be happy with the decision in having to pay the builder or the amount that he had to pay the builder, can still, again, go to court and sue to get the money back that he's already paid, or whatever decision that they think that was unfairly made in relation to the Security of Payment adjudication. The adjudication decision itself does not become relevant in those later court proceedings, but you can go on to fight about it till the cows come home virtually, and if you do issue proceedings in a court or a tribunal in relation to the monies owed, for which there is an adjudication decision, those court proceedings theoretically can't prevent the payment of the Security of Payment Act adjudication. So they still have to be paid. There are some exceptional circumstances, such as insolvency, etc., which I won't go into. It gets a bit complicated. But for most instances, the money is meant to be paid, and if you want to fight about it on another day, by all means, go ahead and do so. Okay. Now, I'll just quickly go through the basic procedure. Again, we can go into this in much more detail if anyone ever wants to come along to the longer Security of Payment Act seminars that I put on, which also gives you an opportunity to sit down face to face with me. I'm hoping that they will take place face to face rather than Zoom, because I like a small classroom where people put up their hand as we get to each particular part that they might have a bit of confusion with, and ask me questions about that in particular, and use examples that they may have that caught them out in the past, by all means. But for today's purposes, a claim is made for payment, and that is the payment claim, as was described in section 3, and I said before, that's effectively your invoice with the endorsement. This is a payment claim made under the Building and Construction Industry Security Payment Act 1999, put on it somewhere, and that makes it a payment claim under the Act. Then the claim is accepted or disputed by the homeowner in these circumstances, and that is called a payment schedule. A payment schedule is anything in writing communicated back to the builder that says, I'm not paying that invoice, that payment claim, or I'm paying less than that amount, and the reasons why they're not paying. It's very important for the homeowner in making a response that they list whatever reasons that they have there and then. And I expect the guide will go through this once it's produced to give the homeowners some assistance. Now, you've received a payment schedule. Now, a disputed claim can be referred to an adjudicator for determination. So in other words, the adjudication. So you've made your payment claim, you've received a payment schedule, which has to be received within 10 business days. And if you don't agree with that payment schedule, they might say, I'm not paying you that at all. They might say, well, I'm discounting the payment by this amount for these reasons. If you don't agree with that, then you can take that disputed part to adjudication by referring it to an authorised nominating authority. And there's payment to the adjudicator. So once the adjudicator has made his decision, he'll then notify the parties, I've made my decision, here's the cost, and his costs have to be paid before he'll release his decision. Now, as a matter of practicality, 9 times out of 10, the claimant pays the adjudicator's entire fee, even though under the Act, both parties are responsible for the adjudicator's fee, but the respondent, the homeowner, very rarely has any interest in the adjudicator's decision. So circumstances up till now between subcontractors and builders and principals in the commercial context, the precedent there is nearly always the claimant pays, gets a decision, hopefully in their favour, and the adjudicator hopefully will add their costs to whatever decision they've made. And that leads to payment. Now, I might just quickly say as well, payment to adjudicator, user pays. Now, the reason I say user pays, that is very important in as much as it costs money to go to adjudication. Now, whether it's cost effective to go to adjudication, you have to make that decision. I usually recommend that it may not be very cost effective up to about $20,000. Some ANAs have a set fee, but if you're paying $1,000 for up to say a $10,000 claim, that's 10% or more. If it's less than 10,000, your claim is less than 10,000, you still got to pay $1,000. It starts getting not very cost effective, and you might be better off going to the tribunal. But again, you give me a ring, we can have a discussion about it to see whether it's worthwhile going to court or tribunal rather than go down the security of payment procedure. But for the smaller claims, it becomes less cost effective than it does for the larger ones, even though the larger ones, of course, will cost you more money. Again, user pays. Okay, keeping an eye on the time. The work intended to be covered by the Act. Now, I'm only going to quickly run through these because it's not terribly relevant when we're just talking about the difference between a builder and or the application of the Act to an owner for payments to a builder. But quickly, it's any construction, including now residential construction and supply contracts, alterations, repairs, additions, civil construction. Most of these are fairly obvious. Demolition, electrical, air conditioning, fire protection, security systems, plant hire, landscaping. Don't forget professional services. They can make security of payment claims against you, the builder. Material suppliers, of course. In other words, just about anything that relates to the activity of building. Now, the Act does not cover a few things, but they're fairly obvious as well. Employment contracts, banks and financial institutions, contracts relating to goods and services supplied for work outside New South Wales. It'll be if the goods and services are supplied outside New South Wales. So in other words, people, builders on the border regions that do work on the other side of the border, it'll be their Security of Payment Act legislation that governs that particular claim. And I don't think Queensland or Victoria, for example, enable you to claim against homeowners at the moment. And work under a contract which was more than 12 months ago. If it's more than 12 months since your claim, since you completed the work, then your opportunity is lost under the Security of Payment Act. It may be lost in any event once you made your final claim under the contract. I'll discuss that very quickly before we run out of time, I hope. Okay, hooting along. Now, who's covered by the Act? Commercial and residential clients, local and state government and their agencies, so let's not forget them. Head contractors, including contractors from interstate undertaking contracts in New South Wales, subcontractors and sub-subcontractors, including residential, of course, suppliers and professional consultants. Again, I'll race through these. Now, applies to all construction contracts, whether they're written or oral. But of course, if you're working in the residential sector, you shouldn't have oral contracts. That'll give you all sorts of difficulties. And they'll probably give you difficulties even using Security of Payment Act. If you've used an oral contract for over $5,000, I think you'll find Security of Payment Act is not worth using and probably not be able to use it. Now, pay when paid, those clauses have gone, but you don't see them anymore nowadays. And you certainly don't see them in the residential contracts. You can't contract out of the provisions of the Act. Well, it'd be the homeowner that would have an interest in that, but they can't, and our contracts certainly don't give any provision for that. Now, if the contract specifies a final date for a progress claim, then you can't use the Act after that final claim. Now, there is some legal opinion going the other way. I don't subscribe to that opinion. In my view, as most residential contracts do, you will have stage claims or periodic claims that you can make as you're going along. And when you reach the final claim, then that's your last opportunity. You can't use the Act after that. So if you're in a situation where the owner has fallen behind claims and you want to try and use the Act to recover it and the final claim's coming up, make sure, if you don't know what you're doing, have a chat with us or engage your own solicitor if need be, but make sure you use that last opportunity to make a payment claim under the Act and see if you can get a quick decision using the Act for the monies that are outstanding. So in your final claim, you can gather in all the shortfalls that an owner has made on previous claims, bundle them into the final claim, make sure you've got the endorsement on it to make it a payment claim, and then see if you can recover it that way. But if there is an oral contract, then you can repeat claims for a period of 12 months after the work's completed. Subcontractors can use that against the builders. But as I said, there's difficulty with an oral contract under residential building work because the Home Building Act says that the contract's got to be in writing, and if it's not in writing, then the builder can't enforce the contract. He then has to fall back on what's called a quantum meruit. And if anyone ever's heard me talk before, the minute a lawyer starts talking Latin, it means it's going to cost you a fair amount of money to recover it. So it is recoverable under a quantum merit, but it's difficult. You probably can't use the Act in my view, and it becomes expensive. So don't do that. Make sure your contracts over 5,000 are always in writing. Between 5,000 and 20,000, it can be virtually a signed quote, or our minor works contract over 20,000, you must use one of the pro forma residential building contracts that complies with the Act to enable you to recover monies. And then after that, the number one mantra that I always have is don't forget, all variations must be in writing, signed by the owner and the builder. That's absolutely essential. You won't be able to use the Act for oral variations. And in my view, when you're doing oral variations, you're almost doing the work for nothing if the owner chooses to. Okay, had to get that one in. And your contract, therefore, is and remains fundamental to identifying your rights and obligations. So the contract's still very important. It governs when you can make your claims. Now, but if the contract is silent, then the Act will establish when you can make a claim. Again, this is very rarely going to occur when you're talking about residential home building market, when you're contracting with an owner-occupier, an owner that lives in or intends to live in the property, because you'll nearly always have a progress claim regime by way of stage claims or periodic claims in your contract. But if perchance you have signed a contract where it hasn't been made clear or you haven't put it in, then the Act will come in and say you can claim on and from the last day for each calendar month. Now, there's no more reference dates, but then again, I won't confuse you with that. That gets into a whole different area of complicated law, and they're gone anyway, so thank goodness for that. Okay, now, if the contract is silent, then the Act will establish mandatory payment deadlines. Now, don't worry too much about the 15 business days because it doesn't apply. That's only in commercial context for a head contractor against a principal. The second point there is 20 business days, again, commercial context for the head contractor to pay a subcontractor. That's my third point there, is only for commercial and residential where you're contracting with a developer, investor, or a strata plan. And then the last point, which is applicable to you, for residential where the owner lives in or intends to live in, then all contracts are payable within 10 business days or any time if by the contract. Now, again, I think 99.9% of residential building contracts will establish when an owner can pay. But again, for that once in a blue moon, if you haven't put that in, or the contract doesn't have a default time in it, then it'll be 10 business days. Okay. Now, moving on, a little bit more explanation on payment claims. Now, so after a payment period finishes, the claimant can serve your payment claim. So again, under a residential contract, at the end of the stage, we've completed all the work, you can then make a claim for that stage. Now, it's fairly easy if you have a stage claim contract because you really just have to claim in your invoice, claim stage one. And because stage one itself is explained in the contract. So that's quite clear, because one of the requirements of a payment claim is the payment claim must identify the construction work and payment period to which the claim relates. So that's going to be fairly clear on a stage claim basis. But if you're claiming otherwise, say for the value of the work done, you're going to have to identify that work. And you're going to have to do it as clearly as possible to make sure that it is considered to be a payment claim under the Act. And you must identify the amount claimed. That's a little bit obvious. 99.999% of invoices will do that. And then you must state that there's a claim made under the Act after the 21st of October 2019. That's a little bit irrelevant now because now you must state it for all claims if you want to make it under the Act. Now, one of the things you're going to have to be a little bit careful of is claiming against an owner. If you're going to make your claim a payment claim under the Act, you're going to have to supply what's called a supporting statement by head contractor. Now, I'm hoping you can see that because I actually don't have a picture of myself. We thought it was too much for me to look at myself for the entire hour. So I hope you can see that. you need to supply and fill out this supporting statement by head contractor with every claim you make that is a payment claim under the Act. So if you put that endorsement on and make it a payment claim under the Act, you must supply this document. If you don't know what I'm talking about, Google supporting statement by head contractor. Maybe put security of payment NSW if you want as well. And that should bring you up a couple of places where you can get a copy of this in a Word format. If you have difficulty with that, then you ring my office and we will send you out a Word copy of this document. Now, one further thing is this document is about to change. At the moment, it talks about, a statement applies for work between certain dates. We have contacted the department and said that doesn't work too well for stage claims, which is the predominant way of claiming in the residential sector. And then there's 2 schedules that go with this document. Again, I hope you can see that a little bit at least, but you can see where you're supposed to write things down. The first schedule is for subcontractors paid all amounts due and payable in relation to the construction work. Now, it's also got a recent change to this document late last year is they put in amount paid. We've made submissions to the department saying you shouldn't have to put in amount paid. That's going to lead to all sorts of difficulties for builders where they disclose how much they've paid to subcontractors, and then you're going to have homeowners straight on the phone whinging about how much you're claiming off them for certain works when you're only paying your subcontractors a certain amount. So they have taken heed of that and said, yes, you're right, we think that's right. We're going to drop that from the next version of the statement, which we understand will be issued in the next couple of weeks. The third page, which is the second schedule, is subcontractors with whom an amount is in dispute and have not been paid. So I've always taken the view that this is a useless document. It was meant to be a document where to prevent insolvency in the building industry, brought in by the inquiry into insolvency in the building and construction industry by Bruce Collings back in 2014. I don't think it does that. It's a difficult document to fill out. It doesn't have any provision in there for subcontractors that you haven't paid but you don't have a dispute with, which is probably the most important part. Whether they do bring that in later or not, I don't know. We will have to see. Okay, now I'm already about to go over time, so I'm going to hoot along a little bit. Now, payment claims, the claim must comply with the contract, so don't forget that. Or if the contract's signed within the Act, but again, that's not going to happen too much. I'm just going to go backwards a bit. I'm sorry about that. Service as per Act. So don't forget that. In contracts, make sure if you serve your payment claims by email, make sure your contract has an email address in there. Our contracts make provision for service by email, but if there's no email address, then you start getting into disputes about whether it was intended email be a satisfactory means of service and which email is it going to be. Okay, I've said there, again, you need to make sure you have a supporting statement. Okay, now just quickly, the payment schedule. I'm not going to take too much time on this because this is really the owner's responsibility. They've only got 10 business days to supply that. If they give you a document in writing that says we're not paying and it's outside the 10 business days, that's not a payment schedule. Okay, so you don't, not that you ignore it, but it's not a payment schedule for the purposes of the Act. But a payment schedule must identify the payment claim to which it relates, which most do, and must indicate the amount of the payment that the respondent intends to make. And if the admitted amount is less than the claimed amount, the schedule must advise why the schedule amount is less and the reasons for withholding the payment. But if an owner doesn't dispute or do not want to challenge the claim, then they need do nothing, and they just do nothing and then pay when it becomes due. Okay, now you've got a deemed admission of liability. So if the owner, I've got you there, but I mean the owner, if the owner does not respond to the claim within 10 business days of receipt of the payment claim, then it's deemed to be a valid claim and therefore payable. And a payment of the sum due is another issue because it's then due on various days after the payment claim is made, and if it's not made, then you're in dispute. So then back to the builder accepting or rejecting the payment schedule. You received a payment schedule, you don't agree with it, or you do agree with it, then you do nothing and you wait for them to pay the scheduled amount on time. If you dispute it, then it's also critical for timing there as well. Okay, they've got a limited time to respond, and if you don't respond with a rejection by way of making an adjudication application, then you're deemed to have accepted that. Okay, and that's how you reject a payment schedule, is you make a written request for adjudication with an authorised nominating authority. Now, if there's no payment schedule and no payment, then you can have two choices. You can either issue court proceedings, and theoretically the homeowner is not entitled to defend it or cross-claim in relation to it, or you can issue what's called a Section 17(2) notice. That has to be issued within 20 business days of when the payment was due but not paid, and the Section 17(2) notice gives a further 5 business days to serve a payment schedule, after which you, the builder, can then go to adjudication whether they supply a payment schedule within those 5 days or not. You've got 10 days after the 5 days expires. So as you can tell from all these timing, the Act can get, it's time dependent. You cannot agree with the other side to extend the times. There's statutory time limits. They're written in concrete. When they go past, there's no going back. So if you don't know what you're doing, you need to get advice on it. You give us a call, you give your own solicitor a call. If you don't know what you're doing, or you have any questions in relation to it, and we can try and lead you through. We can't prepare documents for you. We can't run your matter for you because we are an ANA, but we can give you advice on how the Act works and what you need to do in relation to your particular matter. Okay, that's Section 17(2) notice. That's an example of a Section 17(2) notice. I won't read it out to you given the time constraints, but it says pretty much what I've said before, that you write to them and say, you haven't supplied us with a payment schedule, nor have you paid the monies when they became due. We're giving you an extra 5 business days, failing which we're going to adjudication. Okay, now that's the application for the adjudication. When you make it, it must be made within 10 business days after the payment, after the claimant receives the payment schedule, or when the 5 days of the Section 17(2) notice expires. I should bring that up for you to read, I'm sorry. And the application must be in writing. It's got to identify the payment claim and the payment schedule to which it relates, and it's got to set out the reasons why the claim should be paid. So in other words, if you're the builder, you've made your payment claim, you received a payment schedule, you've made an adjudication application. Your application needs to address all the reasons that the homeowner has said in their payment schedule why they're not paying you. That's your one and only opportunity to put forward your case, for want of a better word, to the adjudicator of why you should be paid and why the reasons the homeowner has raised in the payment schedule are not valid reasons. Now that needs to be put forward by statutory declarations, by yourself, by subcontractors if need be. Any expert reports is usually the best way to deal with defects, an independent expert, and anything else that you need to put forward to the adjudicator. And a copy of your adjudication application has got to be sent to the other side, in other words, the homeowner. Now, the application for adjudication, you can still go to court or tribunal. Regardless, the adjudication fees can be steep. I've covered that. And I've got that, back to too quickly. A payment withholding request can be served on the owner principal, but that's not for you to worry about if you're a residential builder, except the subcontractor can do that on the homeowner, go around you and issue a payment withholding request, but that's a whole another subject. Okay, now I won't spend any time on these. The adjudicators to consider certain matters, the provisions of the Act, the provisions of the contract, the payment claim itself and any submissions you make and documentation in support, the payment schedule that the owners supplied, and the submissions and documents that they have also put in and the result of any inspection, but that's very rare. Now, with the further adjudication procedures, the adjudicator can only consider the adjudication response received in the prescribed time. They can request further submissions from either party, again, not often. They can request a site inspection, that's very rare, and they can set deadlines for both those submissions and any comments, but they can't consider late documents as part of their adjudication decision. Now, once an adjudication decision has been made, if it's in the builder's favour and there's an amount, the adjudication certificate can be issued by the ANA upon an application, and it can be registered in a court as a judgment. Now, I got there, can't wind up, but that's actually changing now, and the courts seem to be swinging the other way, that you can use it to wind up. But again, in the residential sector, that's not going to affect you too much. But now, the potential protected right to suspend work, again, if your contract doesn't give you an entitlement to suspend works, then the Act will enable you to suspend works on a 2-day notice. And I'll just quickly go through that. And here is some of the grounds by which you can suspend work: a payment claim and there's no payment schedule. If there's a payment claim and a payment schedule but no payment as per the schedule, or an adjudicated amount's not paid, then a claimant can suspend works by giving 2 days notice. But again, that's very rarely going to happen in the residential sector, because if you're signing one of our contracts or the HIA contract or even the Department of Fair Trading contracts, it will give you a right to suspend works for non-payment. Now, the final point is disputing the adjudicator's decision. The legislation sees the adjudicator's decision as an interim, and the courts will only allow an appeal where the adjudicator is without jurisdiction. That's very hard, very rare, and I doubt that it's going to happen in the residential sector against an owner-occupier, because you've basically got to go to the Supreme Court. The Supreme Court's going to cost you a lot of money, and it's probably not worthwhile. You're better off delving into the lower courts and re-agitating the entire dispute. Okay, now that's the end of my presentation.